To continue hearing from Mr. Sounes. So could we have Mr. Sounes in, please? Thank you. Good morning, Mr. Sounes.
Good morning.
Ready to continue?
Yes.
Good, thank you. Yes, Ms. Grange.
Good, thank you very much. Yes, Mr. Sounes, I want to start this morning by asking you some questions about the setup and selection of staff for the Grenfell project. And can we start by turning within Mr. Cushill's statement, if we go to that at SEA 000014271 at page 6, to look at paragraph 23. If we blow that up, yes, thank you. And if we look about 6 lines down, there's a sentence beginning a commission. We looked at this with Mr. Cushill yesterday. It says a commission with an approximately 1 million construction value and above would have a director or associate director and a project architect allocated to it. Do you see that?
Yes.
Now, at the outset of Studio E's work on the Grenfell project, was it the case that Mr. Cushill was the director and you were the project architect?
At the outset of Grenfell?
Yes, at the outset of the Grenfell project.
Yes, I think that's correct.
So he's the director, you're the project architect. And were you the principal architect with responsibility for the project?
You have to tell me what you mean as distinct from a project architect.
Well, did you take day-to-day responsibility for the Grenfell project within Studio E?
Yes.
And then can we look at SEA 000014272, page 2. This is within Mr. Cushill's exhibits. And on page 2, at the bottom of the page, we see an email from you to Mr. Cushill dated the 7th of March at 11:37. Do you see that there?
Yes.
Yes, and again, I think we looked at this yesterday. And there we can see that you told Mr. Cushill, if you look at the 4th paragraph down, we can see you say, very happy to front this, might be cleaner and provide a shield for Gary's gripes. And then you go on and say, resourcing-wise, I'm not sure. So just focusing on that little bit for the moment, where you say, very happy to front this, is that you saying, I'm happy to take charge of this project going forward?
Yes.
And Gary there, is that Gary Stewart?
Yes.
And he's one of Studio E's directors?
Well, at that time it was partner, yeah.
A partner, yes, I see. And did you know Gary Stewart to be the person in charge of administering health and safety in relation to projects and site safety?
I think I did know that at the time, yes.
You think you did know that?
Well, it's a long time ago. I did know that, and I think I knew it at the time. Yeah.
And you specifically recall Mr. Stewart taking that health and safety role within the practice, do you?
I do, yes.
Yeah. And what do you mean by the statement that you've made there, or the phrase you've used there, might be cleaner and provide a shield for Gary's gripes? What did you mean by that?
I was an associate, and Gary was I'm appreciate it's a bit uncomfortable speaking on behalf of Gary, but Gary had expressed a view, not just in relation to me, but others as well, that associates shouldn't really be project architects alone. They should be prospecting and winning work on behalf of the practice, and therefore not singularly project architects.
So why would you fronting this provide a shield for his gripes?
It was a client. It was a different client. The TMO was a client, and it was a separate client to the RBKC.
I see. So because it was with a new client,
Yes.
the TMO,
Yes.
a new project, a new initiative, that might assuage him in terms of his concern about associates going out and winning new
And
projects.
just sitting back and
Is
being
that right,
project
what I've just summarised?
Yes. Yes.
Yeah. Sorry, then carry on. You were going to say?
I think I've given well, I don't know if I've communicated what I understand, but the client was a new client, and if I was going to front direct with the client and not Andre, that was in a sense satisfying Gary's expectations as an
Understood.
associate.
Yeah. Now, turning back to Mr. Cushel, is it fair to say that Mr. Cushel was only ever involved at a strategic high level in relation to the project?
Yes, although of course he was kept abreast all the time. Yes, but he didn't attend meetings. No.
When you say he was kept abreast, what kind of information would you keep him abreast of?
Week by week, day by day, what I was
Just kind of
doing.
basic progress, milestones, how you were getting on?
Yes, I mean all the time. We obviously worked very close at all times.
Did he ever review any of the technical work on the project?
By technical work, you mean review drawings?
Yes. Specifications?
I do not recall him reviewing specifications. No.
Or drawings?
Certainly, around the time of the planning application, he would have definitely looked at drawings. I would have definitely shown him drawings.
And what about later? What about tender stage when you were preparing the NBS specification?
I can't recall doing so, but I might well have done. I might well have consulted him on something, but I can't recall.
You can't recall. I now want to look at some of the others that were involved in the project on behalf of Studio E. So, and I'm going to go through them. So we have Marcus Kiefer, and we know that he started working on the project around April 2012. Do you know, or can you recall approximately when he stopped working on the project?
I don't recall. I know his involvement was quite brief, but I can't recall.
And do you know if he had any experience with residential high-rise overcladding?
Not as narrowly, but he may have had some experience with that, but I'm not sure.
You don't know?
No.
Adrian Jess is another figure that we see. You describe in your statement as a senior architect who'd worked on several other projects under another Studio E director, sometimes as a project architect. Is that correct?
Yes.
For the transcript, that's at paragraph 124 of your statement. Is it right that he worked on the project from early September 2012?
I seem to recall that from the documents.
And do you remember when he stopped working on the project?
It was early 2013.
So just for a few months he was involved?
Yes.
And again, do you know if he had any particular experience with residential high-rise and overcladding projects?
I do not recall discussing his previous experience, no.
Okay. Blaine Cagney is another figure. What was his role at Studio E?
As I recall, Blaine joined us as a graduate. So I think he did have some experience, but he had just qualified, essentially.
Qualified, would that be parts 1 and 2? Or
Part 2, he had done his
part 2, but he hadn't done a part 3, so he
No.
wasn't a registered architect.
No.
And again, can you remember his involvement, when was his involvement in the project, roughly?
That is tricky because I know he was on and off involved for quite a long time, but not consistently. So he might have been involved right at the beginning and right at the end, but I cannot recall exactly.
Do you remember the kind of situations when you would get him involved? Was there a particular...
No, it was obviously based on pressure. He was versatile, but he's involved in other projects at the same time.
Yeah. And again, do you know if he had any experience with residential high-rise or overcladding?
As a graduate, no.
No. Then we have Kai Fabiunke.
Fabiunke,
Yeah. And is it right that he studied architecture in Germany?
Yes.
And do you know if he was a registered architect in the UK?
Yes.
Yeah. And he joined Studio E, we know, in 2003 and was promoted to an associate in 2012. Again, can you remember approximately the dates when he was working with you on the project?
Gosh, it was a matter of weeks.
So not very long.
Not very long. It was February, maybe 2013. I'm sorry,
Yeah.
I'd have to.
No, that's fine.
go back.
Okay.
I can't remember.
And again, do you know if he had any experience with residential high-rise or overcladding projects?
In his years, he did discuss his experience, but I couldn't be sure exactly, because I didn't see any pictures, drawings.
And then we have Thomas Reck. We know that he's a foreign qualified architect. He qualified in 2005. And at Studio E, he says he worked as a project architect. Was that your understanding?
Yes.
And were you aware of whether he was a registered architect? Had he done his Part 3 here in the UK?
Most of the European graduates qualify under EU harmonisation rules to register without doing a Part 3 qualification. So I'm not 100% whether Thomas had registered.
It's certainly right that I think with Parts 1 and 2 there were equivalence
True for 3
situations.
as well.
You think for 3 as well? Okay. And is it right that he, Thomas Reck, only worked on the project for a period of 3 months between September 2013 and December 2013?
Yes.
Can we just look at something in terms of resourcing? Can we go to SEA 408352? This is an email of the 6th of September 2013, if we can blow that up. Yeah, this is sent from you to Mr. Kushel. And right at the end, so this is September 2013, so you've done your Stage D report in August 13, and we're looking forward to Stage E, and you say at the end, Grenfell Stage E is quite a lot of fee to earn in a short period. I'm a little anxious about the resource. So is it fair to say at this stage you were concerned about whether you would have sufficient resource for Stage E?
Sufficient resource, sufficient time. Obviously, if you've got more time, you can do more work.
Yeah. And what was it particularly? I mean, we're going to look at the stages later. What was it particularly about Stage E that was concerning you?
Well, that was our tender pack.
Your tender pack was done at Stage E?
Yes, I think we started a bit before September, but it was due to be finished by the November.
Yeah.
Yeah.
Okay. And do you know if Thomas Reck had any particular experience with residential high-rise or overcladding projects?
I'm not aware of it, no, he didn't. I don't recall him mentioning it.
And then we have Mr. Crawford, Neil Crawford, and it's right, isn't it, that he hadn't taken Part 3 of the architect's qualification, had he?
No.
And is it right that he took over from you as the day-to-day contact on the project from July 2014?
Thereabouts, yeah. I continued to be copied into emails.
But he was then in the driving seat in terms of taking the project forward, is that correct?
At that stage, we were through planning, most of planning, not all of planning, and Ryden were on board, and he became the day-to-day contact for Ryden.
Yeah. We'll discuss Mr. Crawford's work a number of times, but just at this stage, can you explain, if he hadn't done his Part 3 qualification, why did you think it was appropriate to have him as the day-to-day contact going forward from July 14?
He had performed that role on several projects previously in Studio E, and I believe at his previous practice. He's having a Part 3 is obviously beneficial to the practice, but there's no it's not a substitute for experience.
Right.
So he had extensive experience.
Is it right that Neil Crawford was the only person in the team that you knew of positively that had residential overcladding experience?
The overcladding bit, combining these all...
Sorry.
I'm pretty confident because I sat in on his interview that I saw the projects that he had worked at, and they were definitely high-rise and they were definitely residential.
Okay, yeah.
But I know he also did commercial
Yeah.
projects.
We're going to look at what he says about those projects in just a moment, but it's right, isn't it, that he wasn't involved until the construction phase of the Grenfell project, was he?
Correct, yeah.
So just looking back and standing back from that team, would it be fair to summarise that the Studio E team on the project consisted of you plus one or two assistants to begin with?
You've missed out Paddy.
Paddy Glennon, is that right?
Yes, I think his involvement was more consistent throughout.
What was his role?
He was an assistant, similar age and level as Blaine.
And over what time period did he assist with the project?
As I say, it was more consistent. I think it was from very near the beginning towards the end of 2013.
Right. So who did you think was working with you on a regular basis during your initial intensive involvement with the project? Who did you see as your key assistants on it?
In 2012, I seem to recall it was mainly Paddy.
Paddy Glennon.
Yeah.
And thereafter, 2013?
Well, from the end of 2012, obviously, Adrian came on.
Yeah.
And I think during that period, we had use of Blaine as well.
Okay. And then you have Thomas Rec coming in
Yes, thereafter.
in the run-up to the specification
Yes,
at the end of 2013.
yes.
Yeah. And in the latter phases of the project, is it fair to say that Neil Crawford was working largely on his own with some oversight from you?
Yes, I mean, there wasn't much call on his time, as I recall. I mean, it was a long period over which he was involved, but he wasn't producing work. He was commenting on drawings and attending meetings, as far as he wasn't producing work, as an architect typically does, producing drawings.
Now, we know that the initial estimated cost of the Grenfell refurbishment was around £6 million, and we know that the cost went up to around £9 million by tender stage. Now, based on what Mr. Cushel has said about resourcing, should this not have justified a larger team, i.e. with a director or a partner, a project architect, and then more associates?
I'm not sure that's how you would make the judgment, no.
So you didn't think that it justified having a more engaged director on the project?
More engaged? No. Andre was engaged. When it came to the planning phase, he was very engaged.
But I think you just accepted that he had fairly high-level involvement,
Yeah.
apart from at the planning stage. Is that correct?
Yeah.
And in terms of experience, is it right that no one on the pre-novation team, my pre-Ryden's appointment, had experience of residential overcladding projects?
We ran through them, and I have to summarise that none that I knew of.
No. Can we just look at the experience that Mr. Crawford had? Can we look at paragraph 21 of his statement? That's SEA 000014275 at page 9. Can you just read that paragraph to yourself for a moment?
21.
Yes, please.
Yeah.
So what we can see from that paragraph is that the Mill Harbour Quarter project that he refers to only got to the planning stage. Do you see that? That's in the
Yes.
third line up. And then he's also referring to the Hardman Square project in Manchester earlier in that paragraph. Can we go on within Mr. Crawford's statement to paragraph 241? This is SEA 000142275 at page 74. And he gives some more details about the Hardman Square project. If we look 3 lines up from the bottom, so he talks about the Hardman Square, Manchester, which Foster and Partners designed for Allied London in and around 2004. I was the project lead for Foster and Partners, and I now recall that Arup Facades assisted in designing the cladding as a facade consultant, with Metalbau Fruc as a subcontractor. So is it right from that that it was Arup Facades there who were designing the cladding as a facade consultant?
I thought Metalbau were, well, I'm familiar with the company, I think. It's the same Austrian company. I
Yes.
think they're the cladding designers.
Yes. Did you know much about Mr. Crawford's experience in this regard when you engaged him on the Grenfell project? Did you speak
Did
to
I know
him?
much? I knew of it, but I don't think he had discussed it with me.
So you
Not
didn't.
necessarily in the context of Grenfell, I must add, but I was aware of a project in Manchester which involved Arup Facades and cladding.
And was that
the-
any part of your thinking when you put him on the Grenfell project, the fact that he'd had this experience?
I think it was, yeah. I think that was our collective thinking. If you're directing that question at me, I think Andre and I obviously thought of it when we suggested putting him on.
It was with reference to that Hardman Square project?
No. Just knowledge that he had experience with high-rise buildings.
Would you agree with me, looking at this, that he's taken one project up to planning stage and there's another project, but he's had some significant assistance there with Metalbau or Arup Facades as the cladding facade consultant?
Has he had assistance?
Well, he says Arup Facades assisted in designing the cladding.
Okay.
What I'm suggesting is that, in fact, his experience of overcladding was actually quite limited when you look at this. Would you accept that?
I think you're inferring it.
Okay.
I don't think that's in any way
Okay, let's move on.
a fair comment.
Okay. Do you accept that when taking on the project, Studio E should have recognised that their existing levels of knowledge and skill would need to be expanded?
I think knowledge, yes. Skill, I think it was within our skills to tackle the project.
At any stage during the Grenfell project, did you consider hiring someone else who did have experience to work on, in particular, the overcladding aspects of the project? I definitely don't recall discussing that. Was
No.
it a thought that ever occurred to you?
I think your question is, again, inferring that we would be designing something specialist, which we did not expect to be doing.
So you didn't expect to be designing the overcladding
No.
for the project?
No.
Because
something as discreet and as sophisticated as an overclad is usually, in my experience, let as a single contract to a specialist subcontractor.
So did you expect to do any design work on it?
We expected to provide the intent and the sufficient for it to be priced.
I see. And did you consider instructing a member of your team to carry out further research into overcladding projects?
Well, there was research done at the outset, and then certainly through 2013 when it became clear that we would not be proceeding with Leadbitter Bouygues, and then the research sort of took on a slightly more, a different focus, because we would be providing tender information for an open tender.
And that research that you talked about at the outset of the project, was that what we discussed yesterday, where you said you went online and you had a look and you ended up finding CEP, is that correct?
Start looking for similar projects and quickly came across CEP, yes.
Yeah. Do you remember what similar projects you found when you did that research? Do you remember any particular similar projects that were important?
I can't mention any by name, but I do know there were a number. I know they sent us drawings, and
Can we have a look now at paragraph 343.4 of your statement? This is at SEA 000-14273 at page 140 at the bottom of the page. So there you say in the first sentence, the building regulations are not straightforward to interpret, and this was a complex project. Now, can you explain in what way you appreciated it was a complex project?
it was a high-rise. It was an existing building with a single means of escape, and that single means of escape was internal. It was a building which was going to be altered quite significantly with the residents in it.
Yeah.
Tackling that is clearly complex.
And is that something, that complexity, is that something that you appreciated at the outset of the project?
Yes, definitely.
But that wasn't something that triggered in you a desire to hire in additional expertise to assist you?
I would argue that's what the consultants were.
Do you agree that the overcladding of the building envelope was by far the most complicated part of the project in terms of design, specification and regulatory compliance?
No.
You don't?
Not at all, no.
So which part of the project did you think was the most complex in terms of design, specification and regulatory compliance?
Well, you've added a lot of
We can break
items.
it down.
You've added a lot of
Which
items
did you
to
think
that.
was the most complex in terms of
The lowest four
design?
floors, the podium level was, the alterations to the podium were considerably complex, both in the design, the number of changes, the routing of the services, coordinating the work, given that it also had to accommodate the entrance and exit from the tower for the residents, and agreeing the scheme with the planning. The lower floor was definitely a challenge. The lower four floors, the podium, as we call it.
And does it follow from that that you'd say it was also the most complex in terms of specification and regulatory compliance?
Given that we were altering the means of escape, having to consider the ventilation and smoke extract to the new residential floors at that level, yes, I would.
And I mean, I appreciate it's difficult this long after, but in terms of the overcladding aspect, where did that fall in your thinking in terms of complexity?
Rain screen cladding itself is quite straightforward, especially when you've got a concrete substrate. You've got if it were a new build and an ideal backing is concrete background for a rain screen cladding. So the existing building was, in a sense, no different to a new build. It just happened to have a lot of people living in it.
So
that's where the
does
complexity
it follow from
lies.
that you didn't think that the overcladding was a complicated aspect of the design?
No, of course it is. Working at height is definitely...
Working at height?
Yeah, well, yes. Of course it's sophisticated and technically complex because of structural, dimensional coordination involved.
And what about risk to the building? Did the overcladding of the building give rise to any complexity in terms of potential risks?
Did it? I think the risk that certainly did occur to us was the weight of the cladding.
The weight, yeah.
Yeah. I mean, it did occur to us, but it certainly was checked by the structural engineers.
Can we now go back to the and look at the 29th of February 2012 email from Mr. Anderson with the initial brief for the project? So we find that at SEA 707 at page 2. So he says on page 2, so this is in the first paragraph after the subparagraphs at the top. We see him saying there, this work will be separate to but complementing calc. It must not in any way compromise the calc project, and we will require assurances and a clear delineation demonstrating this. Do you see that?
Yes.
And that's, we know about the calc project. So is it right that you were required to ensure that you didn't divert resources away from the calc project?
I think that's the more obvious interpretation of that statement, but I'm not sure it's the only one.
What would be the other interpretation you're thinking of?
I think I'm speculating, but when I read
I'm asking
that,
when you
when
read
I read
it,
it,
what did you understand it to mean?
I thought it's relatively straightforward to keep a team separate, but I think they didn't want any anything coming out of the Grenfell project interfering with the progress of the calc project. So whether that be discussing site boundaries or access or I don't know, consultations, any it could be anything.
Okay. Did you understand this to mean that the Grenfell project was a lower priority for the TMO than the calc project?
I don't think that's correct, no.
Did you ever get that impression from your dealings with the TMO that this was a lower priority project?
No, not at all.
Was it a lower priority project within Studio E?
No.
Do you know how many architects within Studio E were working on the calc project?
I'm sorry.
Approximately. I mean,
Approximately, if it was 5, it could have gone up.
Any directors or partners?
Calc.
Yes.
That was Andre, obviously.
Andre.
Yes.
Any other directors or partners?
No.
No. So you had 5.
Well, you've approximately.
Yeah.
I think it did fluctuate, and I'm hazarding a figure.
Sorry, fair point. Approximately 5. Were you ever involved in the calc project?
I was.
What was your involvement?
Primarily in the bid.
Sorry, primarily
In the bid.
in the bid.
Yeah.
So when would that have been?
I think Andre discussed that yesterday, and I think it did start April, May, June 2011.
Yeah.
I think it's been awarded September, October.
So in
I'd say, yeah,
2011.
2011.
Yeah. Were you ever involved thereafter in the calc project?
I was involved a little for a month or 2.
What kind of involvement did you have?
It was just initial discussions about site organisation. I think I attended 1 or 2 meetings.
Did you ever have any detailed knowledge of the specifications for the calc project? For example, what they might have used in the external wall? Was that something that crossed your desk that you looked at?
I think I was aware what they were doing. But that came later.
Okay.
Quite a bit later, but not in. I didn't set about scrutinising it.
Okay.
No.
I now want to ask you a few questions about the impact of Studio E's insolvency. So we know that in August 2014, Studio E LLP was placed into voluntary creditors liquidation. Is that correct?
Yes. Well,
And it was Studio E LLP that was originally engaged to work on the Grenfell project by the TMO. Is that right?
yes.
Can you recall approximately how many employees did that organisation have in 2012? So before the insolvency, roughly what kind of size was Studio E LLP?
I can't recall because it obviously was changing, and I think we have stated somewhere the approximate numbers at the time.
So I think in the opening it was stated to be approximately 45. Would that sound about right?
Yeah, I think we were at our biggest in 2012, I think.
At your biggest in 2012?
I think so.
Yeah.
But I could be wrong on that.
And by the time of the liquidation in August 2014, had Studio E LLP shrunk before that point?
Yes.
By what kind of measure? I mean,
There was a series of redundancy processes.
and do you remember approximately how many individuals were made redundant? Are we talking tens? Are we talking a handful?
Very difficult.
You can't.
Some people left of their own accord, and some didn't. I'm very hesitant to put a figure on it because I think I'd be guessing.
Is it right that Studio E Architects Limited is now a much smaller company than Studio E LLP was?
2014.
Yeah, well, let's say in 2014, was it a much smaller company?
But by mid-20, once the liquidation,
Yeah,
once everyone was transferred over.
yes.
Yes.
Approximately how many employees worked for Studio E Limited by that point, mid-2014?
Sorry, this Studio E Limited.
Yeah. So after the insolvency, which we know is in August 2014,
A figure of 9 to 12.
9 to 12.
Yeah.
Yeah. So is it right that Studio E Architects Limited is a smaller company both in terms of turnover and staff?
Yes.
Was it ever the case that there was limited staff available to work on the Grenfell project after Studio E LLP's insolvency?
No.
You always felt that you had adequate people available?
Yes.
And when the insolvency was taking place, were more senior members of staff, such as yourself, were you diverted away from project work while the insolvency took place?
There was disruption, obviously. We did have to move office. But at the time, we were in a bit of it was a stand-down period.
So apart from moving offices and that kind of disruption, did you yourself get pulled into any work involved in dealing with the insolvency?
I attended some meetings, but I wouldn't say I was diverted, no.
So it didn't affect your project work at that time?
No.
No. I now want to come on to look at Studio E's contractual duties to the TMO, and I'm going to start by asking you questions about the contract between Studio E LLP and the TMO, your appointment to them. Now, as we've already seen, on the 29th of February 2012, Mr. Anderson emailed Mr. Cushel with an initial description of the project, which he then forwarded to you because Mr. Cushel was away. Let's go back and look at that. This is SEA 707. And if we look at the email, can we go to page 1 of that? Yeah. So The email provides the principal objectives of the project. We see that at the bottom of that page. And if we go over onto page 2, in the middle of the page, about 3 paragraphs down after the first lot of sub-paragraphs, we see it says, additionally, commissions will be via the KCTMO and subject to OJEU limits. Do you see that there?
Yeah.
And is it right that OJEU refers to the official journal of the European Union, which is where contract opportunities for public sector contracts are advertised?
Yes.
And then Mr. Anderson goes on to explain in that email the initial stages of the work were to cover 3 stages. Can you see that just below? So he anticipates that there's going to be scoping and outline brief stage, then 2 stages A and B, and then 3 stages C, D, and E. Now, is that referring to REBA stages when we see A and B, C, D, E? Those are REBA
That was my
stages.
understanding.
Yeah. And we're going to look later at what each of those stages might have involved. But for now, I just want to ask you, was it your understanding at that point that the Grenfell Tower services that Studio E LLP was being asked to provide would not be competitively procured?
I'm sorry?
Was it
Did I
your
understand-
understanding at this point that there wouldn't be a competitive tender process?
Well, this was the first email. And the mention of OG limits, I think I initially saw and thought it would be subject to competitive procurement.
Now, if it's not going to be competitively tendered, the estimated value of the contract would have to be less than 174,000, is that right?
I feel that questions on procurement should be directed at those who can best answer them.
Okay.
And that's not me.
Okay.
The OG limits are there to protect public money, and I know that local authorities have to bid pretty much everything. So,
Let's look at an email that you sent. Can we go to SEA 403567? And we see here an email from you to Mr. Cushel, and you say in the first line, in the second sentence, concerned about the emphasis of working at risk while planning to OJEU it all doesn't add up. Now, can you just explain to us here, what does working at risk while planning to OJEU it all mean?
we discussed this yesterday, and it was 20 minutes after the email had arrived, and I had just obviously read through it and seen the reference to the ODU. He had mentioned working at risk, which architects can agree to do to establish the feasibility if they think there's a longer-term view on the project that they'd like to support. And given the scale of the project and the mention of the OGU, I thought that they would intend putting it out to tender.
I see.
That was my initial reading of the email.
And you've explained in paragraph 63 of your statement that you believe that the overall fee to deliver the project would be higher than the OJEU threshold of 174,000. Is that right?
I'm going to hesitate because I think it's come up that on Calc the sub-consultants are all, the other consultants were all sub-consulted through Studio E.
Through you.
As the lead consultant.
Mm. Can we just look at paragraph 63 of your statement? If we go SEA 000-14273 at page 32. And you say in the last 5 lines, the reason I felt his email did not add up was that I believed the overall fee to deliver the project would be higher than the OJEU threshold, and Studio E may not be able to qualify in a bid process. I felt it did not make sense to expose ourselves by working at risk for any length of time. So there's a number of points there that is it correct that you did feel that the overall fee to deliver the project would be higher than the OJU limit?
Well, it was obviously a first response, but the second sentence, I understood that this limit was the maximum contract value. And if we were going to have a full team under us, I think at that point I thought the contract value
Would be more.
would be more.
Yeah. And you're obviously also concerned there about working at risk, is that correct?
I think anyone
It's understandable if you are, but I'm just asking you to be clear. You've said there, I felt it did not make sense to expose ourselves by working at risk for any length of time.
yeah.
Yeah. You then went to site on the 6th of March 2012, and we have an email from you to Mr. Cushel following that site visit of the 7th of March. If we can go to that, that's SEA 000-14272 at page 2. And if we can look at the bottom of page 2. Again, we looked at this email before. Looking at the first paragraph of the email, you say at the end of that, he thought the OJU limit was 175k. I did a quick search and found 99k. So is it right that at this time, you seem to think the OJU limit was 99,000, not 174? Is that correct? Based on a quick search?
Based on that email that
Yeah.
you've got, yeah.
And you also say in the next paragraph that you thought a figure of 5 to 6 million was too little. So you say it's definitely a project, but a poor relative compared to Calc. We'll come to that in a moment. He mentioned hunters arriving at a figure of 5 to 6 million, which sounds too little. So at that point, is it right that you felt that the value of the project would need to be much more than that? This is the construction value, yeah?
It's clearly construction value.
Overall construction cost?
I cannot recall on what basis I arrived at that judgment.
You can't recall that?
I can't recall what basis, what comparison I was using to arrive at that judgment. But
So you don't recall what you thought a reasonable figure would have been at that stage?
I think even that would have been a challenge for anybody to offer at that stage. But as I say, I cannot recall why I thought 5 to 6 sounded light.
Too little. I mean, you did know what the key parts of the project were likely
Yes.
to involve: the heating, the overcladding, the reconfiguration of lower levels.
But to make that statement, I must have had in my mind another project or something similar, but I can't remember how I arrived at that.
Okay. And the bit that we just looked at, where you say it's definitely a project, but a poor relative compared to Calc. Can you explain what you meant by poor relative?
The 5 to 6 million sounded light, too little.
I see. What was the overall construction cost for the Calc project? What was your understanding of it?
I think it was 30 million, I think.
And then, can we look at the second to last paragraph? You say, very happy to front this, might be cleaner. We looked at that for Gary's gripes. And at the end of that, you say, resourcing-wise, I'm not sure. Marcus is maybe not the right person for sketches, massing studies and visuals. Are you referring to Marcus Kiefer there?
Yes.
And is it right that at that point you were not convinced he was the right person for the job?
No, the right person for initial sketches and massing studies, that is usually the sort of work that an assistant would do.
I see. So it was the specific work you could see coming down the track immediately that you didn't think he was suitable for?
Suitable is even unfair. Marcus, very experienced architect, but he didn't use SketchUp. He didn't produce 3D visuals.
I see. He was ultimately used by you on the project, wasn't he?
He was used, yes.
Yeah.
But for a brief period.
Yeah.
And
Now, Mr. Cushel replied that same day. If we go to the top of page 2, that's at 5:38 p.m. And he said he was concerned, we can see this from the first paragraph, that 99,000 would not be enough. He says 99k would be problematic for the services they are proposing, exclamation mark. Do you see that?
Yes.
Do you know whether he shared your concern that a figure of more like 174,000 would also not be enough?
I think at this stage we're not clear what that figure includes,
Okay.
so it's very difficult to comment.
Now, at this stage, you'd not yet provided a fee estimate to the TMO, had you?
No, I think this was, no.
Did you feel, based on this exchange, that you were required to produce a fee estimate that would be lower than the OJEU threshold?
Your fee has to pay for the work.
So when Mr. Anderson said it'd be subject to OJEU limits, did that say anything to you in terms of the cost projections you need to be producing?
Possibly. It possibly suggested that, but I don't think that's how we would necessarily look at it.
Did you ever advise the TMO that you thought the services that they'd asked for should cost more than the OJEU limit?
Did we ever advise TMO that we thought the services would exceed
Yes.
the limit? Again, it depends what's included in that figure.
But do you recall having any conversations with the TMO about that OJEU limit and whether that was achievable for the services you thought were reasonably required?
I can't specifically remember any conversations, no. And I didn't.
We can't see anything in the documents, but we want to know whether you have ever had
Can't
that conversation.
Sorry.
Okay. On the 4th of May 2012, you were informed that the Grenfell Tower project was officially live and that the budget was approved. Can we just look at that email from Mr. Anderson? This is SEA 404136. If we could blow that up at the top. So we can see that you are one of the recipients of that email from Mr. Anderson, where he says, good afternoon all, some very good news for your bank holiday weekend. RBKC's cabinet approved the provision of funds for the Grenfell Tower regeneration project. We're now officially live. And it's right, isn't it, that at this stage, Studio E LLP did not have any kind of concluded contract with the TMO and you were working at risk, is that correct?
Yes, I can't recall how much work we did by this time, to be honest. So, yes, we were involved at risk.
And was working at risk something that you had been keen to avoid?
No.
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 Did the absence of agreed terms and fees have any effect on how Studio E decided to organise itself at this stage?
So it's a bit of a strange question. Did the
Well, you
absence of
haven't
fee
got agreed
agreements-
terms and you haven't got agreed fees. Did that affect
Did
your
we not follow up?
approach to the project?
Did we not follow up shortly after with the fee
Yeah,
proposal?
let's look at that. So on the 12th of June 2012, you emailed a fee proposal and a draft appointment. Can we look briefly at SEA 404561? So this is you to Mr. Anderson, and you're saying, please see attached letter and enclosures regarding our fee and terms of appointment. And then can we go to the letter that's attached? That's SEA 404562. That's dated the 11th of June. So here is a letter where you are proposing, you say, I'm writing to clarify our proposed fees and conditions of service for the proposed upgrade. We get that in paragraph 1. And then we can see there that you've set out a suite of documents that you are proposing the agreement will comprise. Is that correct?
These are all, as I recall, part of a pack of documents prepared by the REBA.
Yes, exactly.
Yeah.
And we're going to come and look at these later in more detail. Can we focus for the moment on the proposed fee? That was set out in Schedule C. We see that listed there as one of the subparagraphs. Can we look at that? This is at ART 50148. And we can see the total fees in the top right-hand corner. Can we see that? Before we get to the table, it says total fees. It says total fees twice. We see 323,000. Do you see that there?
Yes.
And do you agree that's the total fees that you were proposing across the stages, pre and post novation?
I recognise the table. Yeah. I think
Yeah. Did you yourself prepare this?
I would have prepared this.
Yeah. And what it shows is that you're proposing to charge 161,500 for stages A to E. Now we get that. You don't see that figure of 161,000, but we get that by adding up the figures at the top under each of the stages. So if we add stage A to B, 16,000, stage C, 32,000, stage D, 64,000, and stage E, 48,000, you can take it from me that you get to 161,500.
Yeah.
Now, was this breakdown a way of ensuring that the contract with TMO stayed below the OJEU limit of 174,000?
I think you're asking if the allocations on the second row were typical, and I think they are quite typical.
What do you mean by typical? Do you mean a fair estimation of
Typical
the
for
services that would be required?
How we would expect to allocate fee percentages per stage.
Can you give us an overview of how you would go about doing that for a project like Grenfell? How would you come up with these figures? What kind of analysis would go into it?
Sorry, you're asking, first
I'm
of all,
asking you how you've managed to come up with these costings for each of the different stages.
Your first question was whether I had manipulated it to come under the OG threshold.
Mm-hmm.
And my response is that those fee allocations per stage, the 5%, 10%, 20%, to me look fairly typical.
I see. So you take the overall construction cost and then you apply a percentage and you say that's typical.
You take your total fee and then you divide it out by stage
Yeah.
based on experience and what I think what is quite typical with architects. I believe it's quite typical.
So how do you get to the overall fee?
That's based on the 4.75%.
I see. So it's a simple percentage of construction cost and then broken down thereafter into roughly what you think the stages are going to require in terms
Yes.
of percentage
Yes.
time. Yeah,
That's what this is based on.
yeah. And at the time, did you think that this sum was enough to cover the work that had to be done pre-novation?
Well, I think at this stage, I'm not sure novation was clear at the stage.
So we're going to look in a moment at exactly what was said about novation. So maybe let's park that for the moment. Let's go on. On the 18th of July 2012, there's a project meeting number 5, which you attended. Can we look at that? That's ART 50168. So this is a project meeting, Thursday the 18th of July 2012. And we can see you're the last name on the present list. And if you go further down page 1, immediately under the heading Appointments, we then see it stated, A. Dawson gave verbal confirmation that all appointments are approved. However, the TMO would like to subcontract all consultants via Studio E up until stage D, with the total fee up until stage D not exceeding 174,000, which is the OJEU threshold for requiring work to be tendered. This will probably mean deferring some fees post stage D. Now, I want to ask you about that last part. Does the reference to deferring fees mean that Studio E LLP would be paid by the contractor after novation for work that it had done for the TMO?
Yes, I believe that's what was said.
So is it right then that the actual cost of the services required under the contract with the TMO was expected to be more than the OJEU limit?
The TMO would like to subcontract all consultants via the Studio E, so the fee would be increased by the inclusion of the other consultants.
Yes. But then we can see in that final sentence, this will probably mean deferring some fees post stage D. So do you accept that certainly Mr. Dawson is suggesting that the fees of 174,000, whether including sub-consultants or not, are going to be exceeded, and some fees will have to be deferred?
He's used the word probably, and he does refer to stage D.
Did you agree with this statement when you were at the meeting?
I mean, did I agree with their strategy?
Did you agree that it would probably mean deferring some fees post stage D?
I would have to have checked, have to have done an assessment.
You were at the meeting. Do you recall this being discussed?
It's my notes. I could definitely.
To be fair, these aren't your notes. I think these are the Artelia project meeting minutes. So these would have been circulated to everybody after the meeting.
I think you'll find these notes have got Studio E's title block.
Ah, I see. So these were written by you?
Yeah.
And there's no record in these minutes, is there, to Studio E disagreeing with that and saying, no, actually, it's all fine. We don't need to defer fees. We can do it for within that.
This is suggesting taking it up to stage D. It's suggesting as yet unidentified number of consultants to be novated. You would have to assess it in detail to know what your figure is. I don't think at a meeting you could do that.
Okay. And you hadn't done that kind of assessment at this stage?
No, and I actually don't recall doing it.
Now, we can see that a more detailed spreadsheet was sent by you to the TMO on the 27th of July 2012. Can we look at the spreadsheet? That's SEA 407386. We've got that SEA 40. It's one that has to go to offline. And I think we need to be in the Studio E tab at the bottom. Yes, thank you. Now, for stages A to E in this spreadsheet, you're proposing a total of £190,000. And we get that by adding up the 19, the 38, the 76, and the 57. That's if it includes stage E. Do you see that?
Yeah.
So again, you can take it from me that if we add the total fees at the top for A and B, C, D and E, we get to 190,000. Do you recall how you arrived at these fee estimates? Again, was it just applying the simple percentage approach that you talked about earlier?
I think the formulas in the cells confirm that. So
between June and July 2012, is it fair to say that you decided that the initial design work was going to cost a fair bit more than 160,000, which is what the June fees had shown? We see a jump here of 30,000 as between the initial costings that you sent and this spreadsheet.
The changes in the construction cost.
It's because it's gone up to 8 million, is
Yeah.
it? And that's the only change.
The rest of the figures look the same. They're the percentages, I think.
And I think you'd agree with me that the pre-novation fees, if we're looking at stages A to E, if that's pre-novation, we'll look at this question in a moment, in this spreadsheet, exceed the OJEU limit of 174,000.
You just said they were 190.
Exactly.
Yeah.
Yeah. And if we can go to the covering email that you sent, which accompanied this spreadsheet. So this is at ART 50981. This is an email that you sent to Mr. Anderson on the 27th of July. You can see that at the top. And we can see that the fees that you've proposed include a 50% deferment of all Stage D fees to keep the fee limit below the OJEU limit. Now, if you look at, we see that in the sixth, if you look at the black bullet points on the left, if you look at the sixth one down, we can see at the bottom there, it says a 50% deferment of all Stage D fees to keep the total Stage D fee below 174k. Do you see that?
Yeah.
So do you agree with me that at this stage you are amending the figures to ensure that they fall below that 174,000 by applying this 50% deferment?
It says so, yeah.
Yeah. And again, do you agree that less than a month after the TMO approached Studio E for the work, it had become clear that the pre-novation design services were going to cost more than the OJEU limit?
Sorry, this is July, end of July.
Yeah.
We were approached in February.
That's fair, sorry. So within a few months of that approach, do you agree that it had become clear that the pre-novation design services were going to cost more than the limit?
Yes, I think that's what this illustrates.
And is it right that the solution to this was not to put the services out to tender, but instead to agree that some fees would be deferred?
I'm not sure you're asking me to confirm whether it was agreed by all parties or by us or by the client.
Was there ever a suggestion that this increase in fees, maybe due to the increase in construction budget, meant that actually now it ought to go out to tender? Did anyone ever suggest that to you?
I can't recall any discussions on that. It's certainly something that we were well, we clearly are discussing the threshold.
Yeah.
So whether someone decided to put it out to tender, I guess, was up to them.
Up to them. Do you know
Well,
who...
can I just ask, did you ever suggest to the TMO that because of the level of fees, it ought to go out to tender?
I'm afraid I'm not, but I don't have the insight on the OJEU rules as to take a view on what ought to have happened.
Do you know who in the TMO made that decision? Are you ever aware of who made that decision?
In the TMO?
Yeah, not to put it out
Not
to tender?
at all,
No.
no.
Okay. Now, before we move on to the next topic, I'm going to ask you just a few more questions about the effect of deferring Studio E Stage D fees. You've mentioned in your witness statement there were delays in payment by the TMO during the project. For the transcript, that's at paragraph 176 of your statement. Can we now go to paragraph 162 of your statement. This is at SEA 000014273 at page 78. So there you say, if we look at the second sentence of paragraph 162, you say, at this stage, so that's by, we know from the earlier sentence, by the 20th of December 2012, Studio E was working at risk because we were not invoicing because we had reached the OJEU threshold. Do you see that?
Yes.
And if we can look at SEA 406739, if you can blow this up. If we look at, this is your email at the top of the page to Chris Churchman. Now, he's the landscape architect on Grenfell, wasn't he? Or for the landscape architect company. Chris Churchman, do you recall
They
that?
provided landscape services to Studio E for the Calc project, and I think they may have provided some services for a very brief period on Grenfell.
Okay. And if we look in the third sentence of that, he says, we're not invoicing on Grenfell because we've reached the OJ, you say OJRU, should that be OJEU threshold?
Yes.
Yeah. So do you mean that at that point Studio E had submitted invoices up to a value of £174,000?
That's the implication. I can't recall, obviously, the threshold, the limit or the total we had invoiced at that point.
And is it right that at this stage you were still working on the planning application for the project? Is that right? This is November 2012.
Our work had come to a climax with the architect's appraisal panel presentation, and we had gone away a bit unsure what to do, where to take it from there. So we had continued to work on it, but it wasn't. We didn't continue for much longer.
Okay.
Because
What REBA stage would you say you were at around this point?
we were working in REBA Stage D.
Yeah, because you've done your Stage C report in August 2012,
October.
so you've moved on to Stage D. So in the space of 6 months there, Studio E's exceeded its pre-novation budget. Do you agree with that?
6 months. It's more than 6 months.
You were first asked to start working on the project in June 2012.
I think our first meetings were in April.
But whether it's 6 months or 9 months, do you agree that within those months you've exceeded your pre-novation budget?
I guess I am no choice but to confirm what I've written there.
Now, looking at this email, do you agree that there was still a significant amount of work to be done at this stage, including at REBA stages D and E?
E, yes. D, no. We were discussing elevations, agreeing the appearance of the building. I didn't expect that to involve extensive changes to the plans, for instance.
I think I'm right in that your Stage D report was August 2013, is that correct?
Yes.
So that's some time after this, but you're saying there wasn't actually a huge amount more to do in the run-up to that, is that correct?
A lot happened between December or even, I think, April until August. We made numerous changes and reviewed the scope of the project.
Is it right that your understanding was that Studio E would not be paid until it was novated to the design and build contractor?
I think this would not be paid. I think this was the agreement we had.
But is the impact of that you weren't going to be paid for some time on the project?
At this stage in November, we still believe that Leadbitter / Bouygues were very much in the frame.
So you were hopeful that they would come on board and then you would get paid for the work that you had done up to that,
Or beyond that point.
beyond that point.
Yeah.
Did the fact that Studio E was not going to be paid for some time have any impact on the decisions Studio E made about how to resource the project?
Well, at this stage, we were in a sense in a limbo. We weren't working on the project, except I think having occasional contact with the planners. I think this period is covered in some detail in my statement.
Did the lack of payment have any impact on Studio E's insolvency, its eventual creditors' voluntary liquidation?
That's a big question, and I would deny that. No,
To your knowledge, did it have any impact, the fact that you weren't receiving fees for the rest of Stage D and Stage E until?
in my mind, they were not linked. They weren't linked in my mind.
Okay. Mr. Chairman, I think that might be a good moment for the break. We're about to move to some contractual terms.
Yes, all right. Well, it sounds as though we're going on to a different topic now, Mr. Sounes, so we're going to take a short break. Please don't talk to anyone about your evidence or contents of your statement when they're out of the room. And we'll return at 11:30. Yes, 11:30. All right. Thank you very much. I'd like to go with the usher, please.
I think that's...
Good. 11:30, please. Good. Could we have Mr. Sounes back, please? Right, ready to carry on, Mr. Sounes?
Yes.
Good, thank you. Yes, Ms. Strange.
Yes, thank you. I now want to go through some of the specifics of the contract between Studio E LLP and the TMO, and then we'll come and look after that at the contract between Studio E Limited and Ryden. So starting with the contract with the TMO, we saw earlier that you sent on the 12th of June a letter together with a suite of documents based on the REBA standard conditions of appointment for an architect 2010. You say in your witness statement that you would normally expect the local authority to propose terms, but in this case you put forward an agreement based on the REBA standard form. Is that correct?
Yes.
You say that at paragraph 88 of your witness statement. That's for the transcript. And can you explain it? Was there a particular reason why you decided to use the REBA standard form contract terms?
It's traditional.
Yeah.
Yeah, it's traditional form.
Were you familiar with them?
Not very familiar, no.
How often had you used them before?
I can't recall prior to this, and that's not to say we hadn't used them, but in majority of my work at Studio E, previous years had been, we hadn't used REBA forms, they had been bespoke forms provided by the client.
But you nevertheless chose to put them forward on this project.
I remember discussing with the other consultants, and they had all referred to their own institutes' standard forms, and so I
You did the same?
did the same.
Okay. And it's right, isn't it, that Studio E LLP and the TMO did not sign any agreement in 2012, did they?
No.
If we can go to SEA 409820, we can see on page 1, this is an email from you to Artelia, for Peter Blythe and others of the Artelia group, copying in the TMO, dated the 11th of November 2013. And we can see from this email that in November 13, you're still negotiating the terms of Studio E's appointment, aren't you?
You're suggesting there was other negotiations? There wasn't.
The point I'm making is that by this point, you're still negotiating terms. You say, I've run through the contract details. The changes proposed are straightforward, but I think there are two outstanding issues, the form of novation and the collateral warranty. Do you see that?
Yes, yes.
Yeah, so you're still discussing the terms of the appointment.
Yes.
And then if we go on, we can see that the terms were more or less agreed by the 20th of November 2013. If we can go to SEA 409993. And we see here an email from Philip Booth to Claire Williams, copying you in, and it says, Studio E appear ready to sign their contract. Are you happy for them to prepare 2 signed copies for your signature? So it appears to have reached a fairly final stage. Do you agree?
Appears to, yes.
However, you've said in your statement that you're not sure whether any contract was ever signed. Did you ever chase up a final signed agreement with the TMO?
No. Chase up, I think I say in my statement that we have no record.
You've no record of a signed agreement ever having taken place?
No.
Wasn't that something that you were keen to get in order before being novated over to the design and build contractor?
Yes, I don't recall any concern, but I'm...
So you don't recall being concerned that this contract hadn't been finally signed?
I guess I had understood that it would be included in the in the contracts and circulated to the contractors,
Okay. Sorry, do you mean that
the tendering contractors.
as in your agreement with the TMO would be
Yes.
circulated to the tendering contractors?
I think that's what I had assumed.
Okay. Can we go to your witness statement at paragraph 26? That's SEA 14273 at page 11. And here we see you say, from the documents within Studio E's possession, I do not know whether the TMO appointment was ever in fact signed by Studio E and or the TMO. I cannot specifically recall Studio E signing the documents, nor do we have a completed copy on file. That said, I consider that the services Studio E provided in the pre-contract phase were consistent with those services identified in the TMO appointment. Do you see that?
Yes.
So just to clarify, that is your evidence that the services that you provided were consistent with the services that you'd identified in those appointment documents to the TMO?
Yes. With some caveats, because obviously we didn't complete all stages pre-novation.
We'll come on to that in just a moment. So can we take it that when you were performing the services for the TMO, that you understood you were providing the services outlined in those appointment documents?
I think there was confusion around the lead consultant role, but on the core architectural role, yes.
I'm sorry, can I just...
Yeah.
I don't quite understand why you weren't keen to get a contract signed so that you had the terms of your obligations set out and your right to be paid set out. Can you recall what your thinking was about that?
I have no recollection of it being signed, but and we don't have a copy. We couldn't locate a copy. But that's not to say it wasn't signed. I cannot remember.
All right.
And I guess I thought maybe it was, but I don't know. So we really don't know.
Yeah, all right, thank you.
Okay. On your point about the lead consultant role, we will come back and discuss that in just a moment. But can we just follow through with the scope of the services that Studio E LLP provided? Can we look at SEA 404571? Now, this is the REBA standard form, standard conditions of appointment for a consultant 2010. And this is, am I right in thinking these were the terms that you were referring to when you proposed the terms of appointment to the TMO?
Yes.
And can we turn to section 2 of the conditions? That's on page 4 of that document. And if we look at the bottom section of that page, we see obligations and authority of the consultant. And at 2.1, can we see there, it says the consultant shall exercise reasonable skill, care and diligence in accordance with the normal standards of the consultant's profession in performing the services and discharging all obligations under this clause 2. Do you see that?
Yes.
And was that your understanding at the time of what you were contractually obliged to do?
This was discussed, I think, well, it had been discussed with previous agreements. The reasonable skill and care was the requirement for our PI cover.
Yeah.
So I was aware that that was the level of service that we would have to provide. Yeah.
And this is consistent with that?
Yes.
Yeah. And can we look at condition 2.3.1, just below that on the same page? It says the consultant shall inform the client upon becoming aware of a need to appoint other persons other than those named in the project data to perform work or services in connection with the project. So is it right that, in effect, if you thought that additional specialist expertise was required, you had a duty to advise the TMO of that?
Yes.
Can we look at that project data document that's referred to there? if we go to SEA 409823, this is the project data document, which was Appendix A to the contract documents as set out in your letters. And if we go to page 5 of that project data, it lists out the project appointments. Do you see that there?
Yes.
And can we see there, 3 boxes down, that Studio E are the lead consultant? Do you see that?
Yes.
And was that your understanding, that Studio E were performing the lead consultant role?
That's the bit I'm less clear on as to what that may have entailed. I think in part we did, and in part Artelia took that role. So if you're asking me to confirm, I think, I mean...
What gave you the impression that Artelia performed the role of lead consultant?
This is the 2013 version.
Yes, these are the final versions that were proposed by you.
In April 2013, Artelia undertook a slightly different role. There were different people involved, and that was the period referred to in my statement as reinvigoration. And they took a more leading role in advising the TMO.
Was that just a more leading role in practice in terms of how it seemed to you, or were you aware of some kind of formality in terms of Artelia's role?
Yes, there was more formality to it.
Did you ever look at Artelia's contract with the TMO?
No.
Can we have a look at that now? It's at ART 405742. So we see here, this is 9th of July 2014. Please find and close the contract as signed by the TMO. And if we go within this to page 34, and we look at the bottom of that page, can we have the bottom of the page instead? So we see at the top there, the discipline of the consultant, they're there as employer's agent, QS and CDMC services. Do you see that?
Yeah.
And then can you see immediately below, lead consultant? It says the consultant is not the lead consultant. The lead consultant, Bruce Sounes of Studio E. Do you see that?
Yeah.
And is it your evidence that you weren't aware of this during your time on the Grenfell contract? On the Grenfell project, sorry.
I saw this was July 14. I certainly wasn't made aware of it then, or 2013.
So you were never made aware of Artelia's contract that we're just looking at now?
No.
So I want to be really clear, what was it that gave you the impression that Artelia was also performing the role of lead consultant?
I think it's reflected in the correspondence and the notes that they were advising the client on the procurement route, on the briefing, the steps to reinvigorate the project.
Couldn't that be entirely consistent with the employer's agent role, or even the CDMC role, as opposed to lead consultant role?
I'm not sure I can answer that.
Okay. Let's go back to what we were looking at in the contract documents. That's SEA 409823 and page 5.
Can I stop you?
Yeah.
Can we go back?
Oh, to Artelia's contract.
Yes.
Can we do that? Or do you need the number again?
No, it's there.
It's our ART 40.
We've still got it.
Yeah. Employees agent.
Yeah.
In my understanding, is the role of the individual acting on behalf of the client to manage a building contract. I did certainly then, and I'm not sure now I understand how that relates to the professional team. I
So,
don't think...
Just to be
I
clear,
would-
you don't understand how the employer's agent role relates to, say, the lead consultant role?
No, how that would cover the... that covers the management of the consultant's appointments. That, to me, would fall more naturally to a lead consultant.
Okay.
So as I say, you've asked, could the employee's agent role cover the lead consultant role? And my answer is no. Not to my knowledge, because the employee's agent is specifically managing building contract.
So are you saying that because Artelia were involved in some of the appointments of the consultants,
Yes.
that you thought that meant that they had some role in as a lead consultant?
They had taken on, yes.
And that was something what you had just inferred from what they were doing, or was it something you were ever expressly told Artelia are acting as lead consultant?
I can't recall anyone being categoric about the role, but I think it is reflected in the correspondence and the meeting notes. And
Ms. Granger, I wonder if it would help, it would certainly help me and it might help others, if we were clearer about the nature of the lead consultant.
We're about to come to that.
Are we?
Yes.
All right, thank you.
So if we can go back to SEA 409823.
just to go back, sorry, not mentioned there, and I think for the duration of the project, I had always
Sorry, 9823.
assumed that Artelia was acting in some kind of project management role. Now, I know that term is used loosely, but if I had been asked, that's what I would have said.
So let's be clear, you thought they were acting as
Some kind
employer's
of project
agent
well, employer's agent under the building contract,
and lead consultant?
or project manager, and I think there's an overlap between them.
Okay, so you're now saying it was more like a project manager role rather than a lead consultant role?
Yes.
Yeah, okay. Mr. Chairman, we are going to come to look at what these REBA documents say about the role of lead
Yes.
consultant
All right,
in just
well,
a moment. So
When it's convenient to you.
if I can take it in stages. So let's go back to SEA 40, here we are. So there you are named as lead consultant, and there's no caveat to that or additional mention of Artelia there, is there, in that box?
Under lead consultant,
Yeah. It just says Studio E, doesn't it?
yeah.
And then underneath that we have contract administrator, Apple Yards, employer's agent, Apple Yards. And then we have Studio E also as lead designer and architect as designer. Do you see those?
Yes.
And you're also down there as the landscape.
Not at this
Designer.
point.
Is that correct? That might be further
No.
down.
It's Churchman.
Sorry,
Question.
you're right. Sorry, that's an error. Now, did you understand during the project that you were engaged to act as the lead consultant? Forget Artelia's role for the moment. Did you understand that was a role that you should be performing?
I think when I put the document together, I had ticked the box in 2012.
Well, these are documents that come from the 2013 package of information that were put forward in November 2013, just before there's the emails saying Studio E are ready to sign their
Right.
contracts.
Even though it mentions Apple Yards and Churchman.
It does, as contract administrator, employer's agent.
I think by that stage they'd changed their name to Artelia. Okay.
So you're saying these documents weren't corrected to put Artelia in those roles?
I'm questioning whether they were reviewed.
Can we look at page 2 of this document? And this is the schedule of services. Sorry, we're now in the project data. Can we go to SEA 409824? And if we look at page 2, here. So this is the schedule of services, which is Appendix B to the contract appointment documents. And at page 2, we have the section specified roles. Do you see there that some of the details are filled out? Can you see that?
Yes.
And do you see there that the lead consultant is there at A to L? Did you fill that out?
I think I did in 2012, yes.
And it wasn't changed later?
I do not recall, no.
No. And we see lead designer is also stage A to L. Do you see that?
Yes.
So is it right that this document is envisaging a service for the whole project, not just up to the stage when the client procured the design and build contractor? That follows, doesn't it, from stages A to L?
I think in 2012 we weren't clear what was going to happen, yeah.
So you can't explain why the document was completed in this way and form part of that later package of documents?
It appears to have just
Been a hangover.
Copied, yeah.
Okay. Before we look at precisely what REBA defines under these terms, lead consultant, lead designer, architect as designer, we're going to come to that in a moment. I just want to look at the stage at which you assumed you would be working to before novation to the design and build contractor. We looked previously at your original letter proposing terms to the TMO dated the 11th of June. Can we go back to that? That's SEA 404562. And if we can blow up the top of that letter. If you read the paragraph underneath, the sub-paragraphs with the attachments to the contract, we can see you say there, it's not possible to finalise these documents until the stage of the proposed novation is decided and our scope of work is clear. Do you see that?
Yes.
So you're making clear at that point that it hadn't been decided at what stage there should be a novation. Can we now go to the later letter dated the 11th of November 2013, which accompanied the contract docs that you sent to the TMO at that stage? That's SEA 409821. And if we can blow up this letter, so this letter is, I think we briefly saw it at the top, so it's the 11th of November 2013, and we've got the same suite of documents there, and then underneath that, you say, I've attached completed drafts of the schedules assuming a novated appointment. These schedules clarify our intent with regard to cost and time parameters, the consultant team, professional indemnity cover, etc. So at this stage, you're saying, I've attached completed drafts assuming a novated appointment. Do you see that?
Yeah.
And can we go to what your understanding was of the appointment to the TMO and the stages you had to work to? Can we look at your witness statement at SEA 000014273 at page 11? This is paragraph 25. And if we read the second sentence, so it's 5 lines down, you say, my understanding of the KCTMO appointment is that Studio E was to perform the services set out in the enclosures to the TMO appointment, including, as requested by the TMO, to assist in finalising brief and feasibility options, outline design proposals, REBA Stage C, detailed design, including planning submission, REBA Stage D, and technical design, REBA Stage E, and preparation of the employer's requirements. Do you see that?
Yes.
So just to be crystal clear here, you're saying that under the TMO appointment, you understood that you had to perform the services set out in those appointment documents up to Stage E and preparation of employer's requirements. Is that correct?
Yes.
Thank you. Now, you've also said in your statement that, in fact, you believe what you actually prepared was closer to REBA Stage F1. That's the one immediately after E. Can we have a look at that? That's paragraph 241 of your statement at SEA 000147273 at page 105. So you say there, while Studio E had undertaken to prepare a REBA Stage E tender package, I believe what we produced was closer to REBA Stage F1. Do you see that?
Yes.
Can you just explain why you felt it was closer to F1? F1 is production information. That's correct, isn't it?
No.
Sorry, what's REBA Stage F1?
I'm afraid I'm going to have to rely on my experience.
Yeah.
I haven't referred to a REBA definition, but going back many years, I had been involved in projects where, particularly in a two-stage tendering procurement, which this wasn't, which is what we used on Calc. This is the route whereby you appoint a main contractor, and then under a pre-construction agreement, you tender the packages one by one to assemble a final cost for the project, so that it's sometimes called open book tendering.
Okay.
And in two-stage tendering, the contractors don't want complete construction information. They seek complete scope of work to permit inquiries to be sent out for the packages of work. So the emphasis is on the extent, scope, and nature of the work, but not necessarily on the detail.
And in your...
So that is where I understood the distinction between F1 and F2 came from. The one was focused on a tender, specifically subcontract packages.
Yeah.
And F2 was the construction detail. So I'm afraid that's my...
Okay, I understand that about F1 and F2. What I'm trying to get at is, you say you'd undertaken to prepare a REBA Stage E, but that you believe what you actually produced was closer to F1. Was that because you'd prepared tender information? So you'd gone beyond the technical design stage, Stage E, and you've prepared a tender package? Is that why you're saying it's closer to F1?
No, I think it's to do with how comprehensive the information was.
I see. So is what you're saying that the information was more comprehensive than you would expect at REBA Stage E?
Then you might accept for Stage E, yes.
Okay. Can we go to the project brief, which is Appendix D to the contract documents? This is SEA 409826. This is called Appendix D Project Brief, and again, it's one of the pack of documents that accompanied the November 13 letter. Okay, if you look towards the bottom of that page, we see the REBA stages being outlined. Can you see there? It says REBA stages E, preparation of tender documentation, and then REBA stages F2KL, novation to a design and build contractor.
Yes.
Can you just explain what you understood that to mean when you put that together? At what stage was the novation to take place?
At the end of Stage E.
And what about F1? Where's stage F1 on this?
I guess it's rolled into E on this.
I see. So you would envisage from F2 onwards is when you've then gone over to a design and build contractor, and that's the point at which your TMO duties cease and you go over to the design and build contractor. Is that correct?
That's what this brief outlines, yes.
Can we just look at the REBA stages in the REBA outline plan of work? So this is SEA 409824, page 3. So this is within Appendix B. We've got the REBA outline plan of work from 2007 here, and this is where we see the A, B, C, D, E, F and we see F1 and F2. Can you see that?
I can.
And that's, can you see there, this is why I asked you whether F was production information. Do you see that there?
Yes.
But that wasn't something you were aware of, that F was production information?
No, it was production information, but I haven't referred to this, but preparation of information in sufficient detail to enable tender or tenderers to be obtained.
And can we just look at the bottom of the page? There's some notes at the bottom that, in fairness to you, we must look at. It says the activities in italics may be moved to suit project requirements. So is it right that when we're reading this, if there's anything in italics, we need to be aware that they may, in fact, move around depending on the nature of the project?
I wasn't aware of that at the time or since. No.
Okay. Now, if you thought that novation would be at stage E/F1, I think, which is what you've just said, can you explain why we had stages A to L marked as the stages for lead designer, lead consultant, which we looked at earlier? I think you explained that was a hangover, is that correct?
It is, and there's obviously a discrepancy between the cover and what you've just shown me.
Yeah. If we look at Appendix C, fees and expenses, can we look at that SEA 409825 at page 2? (9825). Yeah, so here we've got the fees and expenses schedule. This is Appendix C to the package of documents you sent.
Yeah.
Here, you've actually filled out your fees beyond stage E, haven't you? You've filled them out for F1GH, F2K. So again, that's not consistent, is it, with, or necessarily consistent with novation after E or F1?
Why not? I think it is.
So you don't think it's inconsistent to have spelt out your fees beyond the novation point at this stage?
I think that is novation.
I see. Now let's look at the different roles that you were performing. So if we go back to SEA 409824 and go to page 5 of the document.
I'm sorry, you're moving on, but can you, are you suggesting we would be in a position of renegotiating a fee with a successful contractor?
Possibly. I mean, why not? You don't think that was an option? No, it is an option. That certainly is an option, but that was not... That's not how you saw it?
That's not how it was understood at the time.
I see.
No.
Let's go to page 5 of SEA 409824. And it's right, isn't it, that here we see spelt out in these REBA standard documents precisely what the role of lead consultant involves. Is that correct?
Yes.
So we can't look at all of these now, but let's just take a few. Right at the top, first paragraph, advising on the need for and the scope of services by consultants, specialists, subcontractors or suppliers. Did you understand that to be Studio E's role?
I do remember reading this at the time because I prepared the document. I did expect to discuss it in more detail.
Mr. Sounes, you've proposed these
Yeah.
suite of documents twice. You've proposed them in 2012, you proposed them again in 2013.
I think,
Are you saying now that what's spelt out here for the role of lead consultant, which was clearly marked as Studio E's role, is not what you understood you were providing?
No, I'm not. But I am saying that I put it forward in July 2012 and never got a word back.
Well, we see that it's also being put forward again in November 2013 in your letter that we looked at a moment ago.
Yeah.
So you've been working on the project for a while now. One would think that if you had an issue with being the lead consultant, you could have said that at that stage.
Yes, but clarifying the line between Artilia and ourselves was never discussed.
So is it your evidence that you did not think you were performing the role of lead consultant on this project?
No, I think my statement's quite clear that there was a potential overlap. There was an overlap.
So you did think it was Studio E's role to be performing these lead consultant functions?
There was, yes.
Yes. Can we look at the 5th paragraph down? Can you see there it says monitoring the work of the consultants? Do you see that?
Yes.
So again, would you agree that it was part of Studio E's role as lead consultant to be monitoring the work of consultants on the project as the lead consultant?
Yes.
And it was Studio E's role to ensure that other consultants discharged their scope of work as well?
Yes.
Then if we can have a look at what it says about lead designer, can we go to page 7 within this document? And if we look, for example, at the 2nd paragraph, do you see there, coordinating design of all constructional elements, including work by consultants, specialists or suppliers, and for health and safety matters in conjunction with the CDM coordinator. Do you see that?
Yes.
Again, did you understand that to be your role as lead designer on the project?
Yes.
And who did you understand to be the CDM coordinator?
It was Appleyard's Artelia.
Yes. And then in designers below that, on the same page, if you see the 2nd paragraph down, providing designs, specifications, advice and information concerning the design for which the designer is responsible, with due regard to cost, functionality, build quality and impact, buildability, construction safety, operation and maintenance. Do you see that?
Yes.
And again, is that consistent with the services that you thought Studio E was providing on this project?
Yes.
Do you see a little bit further down that we have a paragraph beginning giving due regard? There's reference there to the good practice in selection of construction materials by Ove Arup and Partners. Do you see that?
Yes.
Did you ever read that Arup Good Practice Guide?
The good practice and selection of construction materials, I think I have, but I do not recall all the detail. But I think I have seen it.
Is it a document that you were familiar with at the time you proposed the contract terms to the TMO?
As I say, I do not recall when I last looked at it.
We're going to look at it just in a moment. But just before we do that, can we also look at the 3rd paragraph down under designers? We've got there determining materials, elements and components, standards of workmanship, type of construction and performance in use for the relevant design. Do you see that as well?
Sorry, which paragraph?
So I think it's the
One
3rd
above?
paragraph down underneath designers, beginning determining materials, elements and components, standards of workmanship. Do you see that?
Yes.
Again, is that consistent with the services you thought you were performing on the Grenfell project?
Yes.
Let's just have a look at the Arup Good Practice Guide. That's at INQ 301120. Sorry, 11220. Thanks. So we can see from the frontispiece that's what it looks like. Do you recall reading this while working on the Grenfell project?
No, I think I'm thinking of the list of deleterious materials,
Right.
not this document.
So if we just turn onto page 3, we can blow up the first paragraph on the left-hand side, where it says the aim of this document is to provide outline guidance for clients and specifiers on how to apply good practice to the selection of materials in construction. This isn't ringing any bells for you in terms of
No.
you reading this, so you weren't aware of it. And were you aware in general that the purpose of this guidance was to promote a change in approach away from simply prohibiting unsafe materials to having a a risk assessment approach and a formal risk assessment to balance risks to health and safety of any particular material against other factors. Were you aware of that?
As I say, I don't think I've seen this document.
Okay. Let's go back to the schedule of services at SEA 409824 at page 8. So it's SEA 409824, page 8. And so this is further on within the Schedule of Services Appendix B, where we get a section which gives a description of the design services at each of the different rebus stages. Do you see that?
Yes.
And if we can look at the bottom of that page, we see C, this is concept design stage. Do you see that? So that's receiving the design brief, preparing the concept design, reviewing the procurement method, etc. You see that there?
Yeah.
And then if we can go over at stage D on page 9, headed design development. And can you look two lines down? It says there, investigating effect of statutory standards and construction safety on concept design. Do you see that?
Yes.
So do you agree that at stage D, you had to understand the statutory standards, such as building regulations, and apply them to the design?
It says investigating effect of statutory standards.
But do you agree, in order to investigate the effect of the statutory standards, you'd need to know what those statutory standards were?
Yes. Yes.
And then we can see below at stage E, which is the technical design stage, we've got consulting the statutory authorities on developing the design, preparing technical designs, calculations and specifications sufficient to coordinate components and elements of the project. And then we've got including information for statutory standards and construction safety. Can you see that?
Yes.
Now, in fairness to you, that's in italics, so that it's possible that that may shift around. It could come earlier, it could come later. Is that correct?
You've pointed that out, yeah.
Yeah. And then at stage F, just to be clear, under production information, we have preparing production information, including specifications in sufficient detail to enable a tender or tenders to be obtained.
Yes.
And going back to your evidence we looked at earlier, your evidence is that in fact on the Grenfell project you took it to stage F1 before novation, isn't it?
I said it was closer. I don't think we were required to.
I'm not saying you were required to, I'm saying your evidence is that in fact you did get to that stage, F1, is that correct?
I think I said closer.
Okay. So are you saying it wasn't F1, it was just an advanced stage E?
Yes.
Okay. And then we have the tender stages, which begin at the top of page 10. And we see at stage K, construction to practical completion. And you can see there, we've got in italics again, reviewing design information from contractors or specialists to establish whether that information can be coordinated and integrated with other project information. So this is how the normal rebus stages work. Do you see that?
Yes.
Once we get
yes,
to the construction stage. Okay. Now, do you agree that it was always envisaged that the design would be at a relatively advanced stage before the project would be put out to tender?
No. If you go back to 2012, no, I don't think that was the understanding.
By 2013, was that the understanding, that it would be at a relatively advanced stage before?
With the departure of Ledbetter Bouygues, I think it was understood that an open tender would have to be more detailed.
Yes.
Yes.
So I think you're accepting that certainly by that stage it was clear that the design would need to be at a relatively advanced stage before tender.
It didn't need to be, but that was agreed
That was agreed, and that's what you understood?
Yes.
Yes, thanks. And do you agree that under this appointment to the TMO, Studio E had to carry out an investigation of the statutory standards before that novation occurred?
Do I agree?
Yeah.
I
Do you agree, looking at this, looking at all those duties that we've just looked at under this appointment, that you had to carry out an investigation of the statutory standards before novation?
I think the statutory standards are covered by the whole team, and I think they're covered in the stage C and D reports.
But did you understand it to be Studio E's responsibility? Forget about anybody else who might have that responsibility as well.
Yes.
Did you understand it to be Studio E's responsibility at stages C and D to be investigating the statutory standards?
Yes.
And that would include the building regulations 2010 and the requirements under those, yes?
Yes.
Just finishing off this document, can we just move to page 11 where we've got other services? We can see on page 12, box 18, that the electronic document control system is crossed out. Do you see that there?
Yes.
Can you explain why that was crossed out?
Common practice in the industry with any contract of a reasonable size is for the contractor to manage their documents on an online platform. And that could fall to a consultant, but it usually falls to a contractor in a design and build.
So is what you're saying that it was your expectation that you as Studio E didn't need to provide this because this would be something that the design and build contractor would be providing during their appointment?
No, it's not a requirement. It's as I say, it's become common practice.
Would you say it's good practice to have an electronic document control system?
I think it is, yes. It allows you to manage the documents.
Okay.
Yeah.
We're going to come back in a later topic to look at document control and what document control Ryden had and what Studio E had on the project. So I'm not going to ask you more questions at this stage. Can we just look at box 19 while we're here? You've got compiling maintenance and operating manuals. That's also crossed out. So again, just to be clear, it was your understanding that Studio E didn't have a role in compiling maintenance and operational manuals?
No, we have a role, but we weren't responsible for collating them.
I see.
That would always fall to the design and build contractor.
D&B contractor as opposed to, say, Artelia in its role as CDM coordinator?
The reason it's crossed out is that in a traditional contract, the architect would typically take on that role. But in a design and build, it's
not necessary.
It's the contractor,
Okay.
usually.
Yeah. Do you consider that the terms of this appointment were suitable for the Grenfell project?
Yes.
And did you think they were suitable for a design and build arrangement where there would be novation to a design and build contractor?
Yes.
And do you agree that if Studio E was going to be providing these services that we've just discussed to the TMO, it had to be aware of the requirements of the building regulations, including Schedule 1, Part B on fire safety,
Yes.
and the associated statutory guidance, approved document B on fire safety? Studio E would have to be aware of the requirements and compliant with those?
I think that's a slightly more difficult point as to how aware.
So did you think that Studio E had to have regard to the guidance in approved document B on fire safety?
Yes.
So I now want to look at the basis on which Studio E carried out work for Ryden following Ryden's appointment. Can we go to paragraphs 30 to 31 of your witness statement? This is at SEA 000 14273, page 14. If we could zoom in on those. So there you say, initially, Ryden engaged Studio E LLP under the same terms as the TMO appointment, but for only those services that related to the construction stage, for a short period of time in June and July 2014. However, and as set out further detailed below, after Studio E LLP became insolvent, Ryden engaged Studio E Limited to continue on the project. And you say, I believe that Studio E LLP's appointment with Ryden took the form of a novation, although I do not have any documents that evidence this. I do not recall specifically when this would have occurred, but essentially Studio E LLP's obligations transferred from the TMO to Ryden through the legal process of novation. Studio E solicitors have advised me that novation is a technical legal term used to describe a substitution of a new contract in place of an old one. So I just want to be clear about this. Is it your evidence that Ryden did engage Studio E Limited under the same terms as the TMO appointment for a period in 2014?
It is, yes, although we didn't do much work in that period. Yeah.
What was it that gave you the impression that Ryden had engaged you as Studio E LLP at that point under the same terms?
I think my first meeting with Ryden was in April. So until June, there were conversations ongoing, but I don't think we had commenced any kind of work. So
did you ever?
I hadn't. I obviously did discuss terms, but discussed our ongoing work with Ryden, but I don't recall any conversation which disputed the understanding that we would be novated.
So there's an understanding that you will be novated, but
Yeah.
Isn't it a separate thing whether you have in fact been novated and are then appointed by Ryden?
The new contract, yes.
Did you ever have any conversations with Ryden to the effect of, yes, we as Ryden have now engaged you, Studio E LLP, to act for us pursuant to these same terms? Did you have that conversation with Ryden?
I don't think I did, no.
So you're saying it was just an assumption that you made, is that correct?
I think it's a bit more of an assumption. I think it was reflected in the conversations and the correspondence.
Can you recall which conversations you had to that effect? With who at Ryden?
Not individually. I mean, I know there are mention of meetings in my witness statements, but they're not noted.
Isn't it actually right that Studio E's novation and appointment to Ryden didn't happen due to Studio E LLP's insolvency, and instead Ryden appointed Studio E Limited?
I think if I recall, there were one or two invoices which went out prior to prior to the liquidation. I would use those as
Invoices going to
Ryden,
Ryden,
yeah.
Which you say were paid.
Yeah, if I recall. I think there were two.
But it's right, isn't it, that Ryden and Studio E Limited didn't use the REBA standard forms, but instead agreed bespoke terms?
Yes.
Now, I want to look at this. On the 17th of April 2014, we can see that Ryden sent Studio E a draft schedule of services. Can we go to this? This is at RYD 000064706. RYD 000064706. Is there a problem with that reference?
At the moment, sorry.
Okay. So we can come back and look at that. That was an email on the 17th of April 2014. Aha,
You may have it up.
we have it. Great. Okay, if we can look at the email, the second email down at 16:24. Here we have Simon Lawrence sending you, Grenfell, draft schedule of services. And he says, please see attached a draft schedule of the services document that we're proposing to send you. We can discuss further next week. Do you see that?
Yep.
And then on the 30th of April 2014, so a couple of weeks later, we see an email at the top of the same document back from you responding to Mr. Lawrence with your comments in markup. So we can see there the email, and it attaches schedule of services markup document. And you say, hi, Simon, I could have returned this almost immediately. Apologies. I've highlighted my comments. It needs to go out to our insurer, and they will need to see the warranty as well. Do you see that?
Yeah.
Now, I want to look at the attachment that you sent at this stage. So this is at RYD 000014215. And what we see in this document is the draft that was sent to you by Mr. Lawrence, and then we see your comments in comment bubbles on the right-hand side. Do you see that?
Yeah.
And if we can go to page 3, this is the schedule of architectural services which Ryden were proposing for Studio E's appointment. And then we see under item 7, generally, we can see there that the proposal was that it said obtain building regulation approval for and on behalf of the contractor. And I think we can see from your comment, you've said too onerous given the scope of building control approval and our inability to commit you, our employer.
Can we scroll that
Yeah,
up?
we might.
Because
Can we
we've
take
got
that up?
That's it, thank you.
Yeah, that's better. Too onerous given the scope of building control approval and our inability to commit you or our employer to any requirement. And you've then, I think, proposed alternative wording. Do you see that there?
Yes.
You've got, in quotes, responsibility for coordinating building control submissions. Do you see that?
Yes.
So you're proposing alternative wording on item 7. And then if we look at item 10, which says seek to ensure that all designs comply with relevant health technical memorandums, etc., to do with the NHS publications, you've commented not relevant. Do you see that?
Yes.
And there were a few other changes by you in this document, but they relate to issues that we're not concerned with, such as acoustics. So can we agree, looking at this, that you've got no changes or suggested comments on item 8? Do you see that?
Yeah.
Seek to ensure that all designs comply with the relevant statutory requirements, including scheme development standards.
Yeah.
Item 13, at the bottom, with other consultants where appointed, develop the scheme designs, agree with the contractor the type of construction and quality selection of materials. Do you see that?
Yes.
And item 14, if we can go over the page, we've got coordinate any design work done by consultants, specialist contractors, subcontractors and suppliers. Do you see that?
Yes.
So is it right that you never proposed any changes to those and you were aware of them from April 2014?
Yes.
Now, the agreement was not signed at that stage, was it?
No.
Do you know why not?
I don't think anyone from Ryden returned to us regarding my comments until...
So no one from Ryden got back to you.
No.
Again, were you not anxious to get in place a clear contract with Ryden that set out what your responsibilities were?
No, I wasn't anxious.
We can see that the final text was sent by Ryden on the 14th of December 2015. If we go to SEA 000013741, we see an email from a Mr. Daniel Banks, who I believe is a trainee solicitor at Ryden, to you of that date,
Yes.
where he says, thank you for your email. And then you previously commented on the form of warranty and deed of appointment. He says, sorry, just before that, he says, I'm conscious we've got outstanding appointments and warranties for the following job: Lee Bridge Road, Frognall Place, and then Grenfell Towers. You've previously commented upon the form of warranty and deed of appointment. Having considered your comments, I confirm that the majority of your amendments have been accepted, save for the net contribution clause, and he sends tracked documents attached. I trust these are now in an acceptable format and shall issue engrossments in due course. And then we don't need to go to this on screen, but for the transcript, on the 20th of January 2016, there was a letter from Ryden with finalised documents sent to Mr. Crawford and yourself. That was SEA 000013878. Can we look at your witness statement next, which is paragraphs 473 and 474. This is SEA 000014273 at page 184. So 473 and 474. Can you just read those two paragraphs to yourself?
Yeah.
So you say there that at this stage, Ryden was keen to have the contract documents signed off because it wanted to achieve practical completion and it required collateral warranties to do so. And you also say in the last sentence of paragraph 473, you say, in my experience, it is common for contractors to put pressure on the design team to accept onerous terms. Now, are you saying there that you felt pressured by Ryden to sign the contract at this stage?
Yes, we were.
Was it your view at the time that the terms proposed by Ryden were onerous?
Yes, my understanding is they were uninsurable. Yeah.
Which terms were onerous? Which ones in particular?
I think unlimited cap, I believe, is uninsurable.
That was your concern, was it? Did you have any concern about the schedule of services that we just looked at?
I don't recall raising any comments on the schedule of services.
No.
But that's obviously wasn't the priority. The priority was the liability.
Did you speak to your insurers at the time about the concerns you had about this being uninsurable?
It was my understanding. I know that because he mentions in his email that we had been in discussion on the warranty. I think I would have had conversations.
Do you have a specific recollection of that, though? That's what I'm asking you. Can you recall speaking to your insurers about this?
No, sorry, I can't remember specific conversations.
Do you agree that the amendments that you made to the schedule of services had been accepted and they were reflected in the finalised text that was sent to you?
Since, yeah, I see they were.
And is it fair to say that you had plenty of time to consider and object to the terms in the schedule of services, given that you had been sent them back in April 2014?
No.
You didn't have plenty of time to consider those and object to them? Is that what you're saying?
I'm saying in 2016, once they came back, once Ryden returned with documents they wished to formalise, it was time critical to agree to them.
But there's no record, is there, of you raising any concerns at that stage about the schedule of services?
No.
No. We're going to go through those terms in a moment. So let's look at RYD 000094228. This is the final agreed text signed on the 3rd of February 2016 between Studio E Limited and Ryden. Now, just looking at the date there, so this means that the final contract was not in fact signed until after Studio E Limited's work had largely been completed. Is that correct?
Correct, yeah.
Can we turn to the terms of that written agreement in more detail? Can we see from page 2 of that document at the top of the page that the deed is made on the 3rd of February between Ryden Maintenance Limited and Studio E Architects Limited? Do you see that?
Yes.
And on page 3, at paragraph 2.1, do you see there it says the consultant has and will continue to perform for the contractor the services in respect of the development? Do you see that?
Yeah.
And the words has and will continue to perform, did you understand that to mean it had retrospective effect? Did you consider
Yes.
that at the time?
Yes.
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 And can we look at paragraph 2.3 as well, just below that? So it says the consultant warrants it has exercised and will continue to exercise reasonable skill, care and diligence in the discharge of the services to the standard reasonably to be expected of a competent professional experienced in the provision of professional services for work similar to the size, scope, complexity, quality and nature of the development. Do you see that?
Yes.
And you were aware of that at the time, yes?
I think I would have challenged that, but I didn't, obviously. Normally I would
What does
have
that mean?
challenged
I think I would have challenged it.
Well,
You did, in fact, challenge this clause? You did, in fact, raise a query about it? Or looking at it now?
And if something is usually if it's clearly inconsistent, then you would say so.
Are you saying this is inconsistent with the services you provided to Ryden?
No, I'm not saying that. But it is implying a pre-existing experience, which we didn't have.
Well, it's saying it's to the standard reasonably to expected of a competent professional experience in the provision of professional services for work similar to the size, scope. So isn't it a theoretical, competent, experienced professional?
Yeah.
Yeah. So it's not saying you had that experience. It's saying your services are to be compared with that theoretical comparator. Do you agree?
Yeah.
Yeah. And if we look on paragraph 8 on page 5, there's also an obligation to use reasonable skill, care and diligence to comply with its obligations as designer under the CDM regulations. Do you see that?
Yes.
And we're going to come back to look at CDM later. I now want to look at a number of specific parts of the schedule of services at Annex A. So it begins at page 8 of this document. And if we look on page 9, if we can look at item 4, if we can go down the page. So here we see the schedule of services which Studio E had signed up to in this contract with Ryden. And you see at item 4 on page 9, seek to ensure that all aspects of the architectural designs comply with the employer's requirement documents prepared by Artelia UK. Do you see that?
Yes.
And was it your understanding that that's what you had to do in providing the services to Ryden?
Yes, although I don't remember considering that at the time, yes.
When you say you don't remember considering it at the time, did you ever look at this schedule of services and say, well, let's just check that it is consistent with the services we've been providing to Ryden?
Sorry, that one does say all architectural design comply with the employer's requirement documents.
Yeah. Is that what you thought Studio E was contractually obliged to be doing for Ryden?
Yes. Sorry, I had thought it just said complies with employer's requirements in total, but it doesn't.
Okay. Item 5, advise the contractor where, in the architect's opinion, there are shortfalls within the employer's requirements and advise of assumptions to be made. Do you see that?
Yes.
And then item 7, can you see responsibility for coordinating building regulation approval for and on behalf of the contractor? Do you see that?
Yes.
So we can see that they've accepted your wording that you're responsible for coordinating the approval rather than gaining the approval.
Now that you've put them up side by side, the word I used was submissions.
So responsibility for coordinating building regulation submissions.
That's the wording I remember you've just indicated.
Do you accept that Ryden had responsibility for coordinating the building regulation approval for and on behalf of the contractor?
Right, Ryden? Or
Sorry, Studio E.
At that point, we had agreed to coordinate building control.
Approval.
Under duress.
Is there a difference between submissions and approval?
Yes, I think I could argue there was.
Okay. The term statutory requirements isn't defined. We see item 8, it says seek to ensure that all designs comply with the relevant statutory requirements. Did you understand that that included the building regulations
Yes.
and the CDM regulations?
Yes.
And then we can see at item 9, there's an obligation in accordance with the CDM regulations to undertake a design risk assessment relating to the works that are part of the architect's brief. Do you see that?
Yes.
And then we can see at item 12, with other consultants where appointed, develop the scheme designs, agree with the contractor the type of construction and quality selection of materials. Do you see that?
Yes.
And I think you confirmed earlier that that's consistent with the services you thought you were providing to Ryden.
Quality selection of materials is a bit ambiguous, but yes.
Sorry, I didn't catch that.
The last phrase, type of construction and quality selection of materials, is a bit ambiguous. But
What would you understand that to mean?
Type of construction. I think the word selection shouldn't be there.
I see. So you think it's
Type of
should read
construction
in
and
the
quality
of materials.
Yeah.
And that would implicitly include selection of materials in compliance with relevant statutory standards, wouldn't it?
Yeah.
And then item 13 on page 10, we can see coordinate any design work done by consultants, specialist contractors, subcontractors and suppliers. Do you see that?
Yes.
And then we have item 27, if we go down. We see examine subcontractors and suppliers' drawings and details with particular reference to tolerances and dimensional coordination, finish, durability, appearance and performance criteria and report to the contractor. Do you see that?
Yes.
And again, is that consistent with the duties you understood you were providing to Ryden?
Yes.
And then finally, under item 31 on page 11, we can see, if we zoom in, under this schedule of services, Studio E are obliged to be providing certain types of drawings, including, we can see 1 in 5 drawings of various aspects of the external wall. Do you see that at little a?
Yes.
Again, was that consistent with the services you understood you were to be providing to Ryden?
No.
So can you explain why someone has signed this contract with 1 in 5 drawings in it when you didn't understand you were to be providing 1 in 5 drawings?
It was 2016. The building was largely complete. We were under pressure. And I can almost hear a conversation which was, well, what's the issue? It's done. It's completed.
Okay. Can we just look?
I think I had a conversation to that effect with someone at Ryden. In other words, why dispute a minor point when the project's finished? So
you didn't think it was worth disputing?
Yeah.
You just lived with it, even though you knew you hadn't produced 1 in 5 drawings?
Yes.
Can we just look back at item 13 on page 10, just for a moment? The word coordinate there, coordinate any design work done by consultant, specialist, contractor. What did you understand coordinate to mean in practice?
The consultants and specialist subcontractors have specific elements of work which often potentially conflict or need to be coordinated in such a way that they don't. And that is usually the role of the architect to discuss and agree between different parties how different trades come together.
Would it include identifying gaps in scope? You know, one subcontractor seems to be doing X and another Y, but there's a gap that needs filling in order to ensure compliance.
No, I wouldn't.
It wouldn't?
No, it's very much a sort of practical, spatial construction issues, usually at this stage, that you're considering.
Following Ryden's letter of the 20th of January 2016 proposing these final terms, did you actually check this deed of appointment to see if it accurately reflected your understanding of the work that Studio E Limited had been asked to do?
I think I mentioned that I realised that it didn't exactly because of the lists of drawings.
Was that the only respect in which you felt it didn't accurately reflect the services you'd provided?
I didn't do a detailed review of it at that point.
So you're not aware?
For that very reason, we were under pressure.
Did you actually check to see whether Studio E had, in fact, carried out the services outlined in the schedule of services?
I think that's the same question. I was aware of the services we had provided, and I was aware that the document wasn't 100% in alignment with it.
Do you know if anyone else at Studio E may have checked that in fact they'd carried out the services in the schedule of services?
I think I was the one who would have looked at the document initially.
So there was no one else that...
Andre, my director, he would have received the document and no doubt looked at it, but I think he would have expected me to raise any issues.
Okay. Can we look at paragraph 35 of your statement? This is SEA 000-14273 at page 15. And you say there in the first sentence, Studio E's role during the post-contract REBA stages F and K included coordinating the detailed design of others, including the engineers and specialist subcontractors, liaising with planning and building control to achieve statutory approvals, and responding to site queries. Now, just looking at that there, was it your understanding that Studio E's role was limited to coordination and responding to queries?
Yes.
did you believe at the time that there was no requirement for Studio E to check the work of subcontractors to ensure that it complied with, for example, the building regulations?
No, there was no expectation on us to do that.
That was your clear understanding, was it?
Yeah.
Based on what?
The individual, well, a lot of the work fell to specialist subcontractors who held design responsibility for their work. Obviously the cladding, but also a lot of the internal works on the services, and it would not, in any event, fall to us to check compliance. Compliance would fall to the specialist themselves to check. That's almost asking us to provide a certification role in which we didn't have.
But so why did you agree to item 8 of the Schedule of Services, which says seek to ensure that all designs comply with relevant statutory requirements?
I think that's not the same as confirming compliance. I think that's...
So seeking to ensure that all designs comply with the relevant statutory requirements, what would you envisage that would entail?
Well, clearly as having a role as coordinating the applications, you would receive comments back from building control and take them up with individual contractors.
I see.
Designers.
So in discharging that, is it your position that your role was limited to passing on any comments from building control about statutory compliance?
Yes.
Can we look at Mr. Crawford's witness statement at paragraph 16? This is at SEA 000-14275 at page 7. So there he says, we did not have a formal deed of appointment with Ryden until the end of the project, which is not uncommon. However, from the outset of my involvement, Simon Lawrence Ryden made clear to me that Ryden would contact us when it required, and so I would coordinate responses to queries as and when we were asked to do so by Ryden. Studio E had responsibility for coordinating the building regulations approval process. Now there he says that from the outset of his involvement, Simon Lawrence made it clear that Ryden would contact Studio E as and when required. Were you aware of this?
Yes.
Did Simon Lawrence ever say that to you?
He did.
Can you recall exactly what he said to you?
I think it's in my statement. Something to the effect that Ryden typically don't. Well, is it in my statement?
Yeah, I'll take you to that, in fairness to you. Let's go to paragraph 33 of your statement. We were about to go to it. So it's SEA 000-14273 at page 14. And if we look at the third sentence, 4 lines down, you say, I was aware from early conversations with Simon Lawrence that it was Ryden's intention that Studio E Limited would have less of an intensive role than Studio E LLP had under the KCTMO appointment. Do you see that?
Yes.
So are those the words that he used, less of an intensive role?
No, I think that's me summarising it.
Can you recall when you had this conversation with Mr. Lawrence, approximately?
No, no, I don't. And I think there were more than one, but I can't remember. It was near the beginning. I mean, it was long before the work started on site.
Did it occur to you to get that reduced into writing
No. I wasn't. No.
But what did you take that to mean in practice? Less of an intensive role. What did you think that actually meant in terms of what Studio would be doing for Ryden?
Well, less queries, less requests for drawings or details. He didn't say exactly, but he did imply that that was the Ryden. I wouldn't say it's his, but that's what we could expect. That it would be probably less than what we were expecting.
And on the basis of that, did you adjust your work going forward? Did it affect the way Studio E approached its role in practice?
Our role became, I think it's possibly used elsewhere, but not in my statement, but more reactive, more we were asked and responded as when asked.
As and when required?
Yes.
How did that fit with the obligations that we've looked at, which you knew about from April 2014 in the schedule of services? How did that as and when required role fit with what we've seen in the schedule of services? Did you ever have that thought? Did it ever occur to you?
That there was a...
Well, on the one hand, I'm being told it's as and when required, a less intensive role. But on the other hand, I've just seen this schedule of services and it's pretty extensive, what we have to do. Did that disconnect ever occur to you?
No. What did it occur to me? We worked for most of the project without an appointment. So the disconnect wasn't real.
When that draft appointment came in April 2014, that we looked at where you made some comments, did you share that with Mr. Crawford at the time? Did you discuss it with him?
I don't recall discussing it with him, but I think the understanding on the building control liaison was understood. I'm pretty sure we discussed that.
I understand that. I'm not specifically on building control here. I'm talking about more the kind of obligations like we saw in paragraph 8, ensure the designs meet the statutory requirements.
I'm not sure that's more onerous than what
you're describing.
What I'm describing, yeah.
I see. Mr. Chairman, I think that's an appropriate moment.
Yes, all right. Thank you. Well, Mr. Sounes, we're going to stop for a break now. Please don't talk to anyone, excuse me, about the evidence you're giving or your statement or anything else to do with the inquiry, all right, over the adjournment. And we'll resume at 2 o'clock, please. All right, thank you very much. I'd like to go to the usher. 2 o'clock then, please.